if you want to proceed into the agenda, where we left off, we do have a short briefing for you on the federal consistency process. Mark Delaplane is here to do that. I know there's been some questions over the last several months about consistency in the context of projects, but this is a general overview and an opportunity for you to think about that process and the tool we have there and how it works or not.
Thank you. I have a PowerPoint presentation. I apologize to any commissioners that are anxious to get back on voting, but another history lesson is about to occur. This is what many people consider the reason for the Coastal Zone Management Act being passed, certainly an outgrowth from the 1969 really horrendous Santa Barbara County oil spill. And 3 years later, both the Coastal Act and the Coastal Zone Management Act were passed. That act, the Coastal Zone Management Act, would, as we give authority to local governments and local coastal plans when their plans are done, once our program was federally approved, we would get the authority to review projects for consistency with the Coastal Zone Management Act on a procedural basis and under the Coastal Act from a policy perspective. Some of the major issues really centered around oil drilling and where was it going to be occurring, in what manner, how was oil going to be transported, and some of the really big battles in the early days of federal consistency and many of the lawsuits centered around how those issues were going to get resolved and where the Commission's authority lay, and how far the Commission could push the resource protection and how far out into the ocean beyond the 3-mile limit of state waters. To me, the best illustration for why we needed the CZMA, if anybody had any doubts, was back in 1976, before our program was approved, Exxon wanted to place the offshore storage and treatment vessel inside the 3-mile limit, and they came to the Commission for a permit, but they didn't like the permit conditions. The Commission was adamant about extensive requirements for transportation of oil by pipeline rather than tanker because of the way that tankers can release much larger spills. And so because Exxon didn't accept the conditions and because our program hadn't been approved by the federal government yet, they just parked the OS&T 3.1 miles offshore just outside the limit of state waters. So again, the CZMA was a vast expansion of the Commission's authority onto federal lands, over federal activities, and certainly in federal waters. Some of the basic principles of how federal consistency is supposed to work. It's really a collaboration and communication tool, a coordination, and when a federal agency comes to the Commission or an applicant for a federal permit, they come to us with their analysis about why their activity is consistent with Chapter 3. We're agreeing or disagreeing with them, but they come in on an equal, the federal government certainly has an equal footing, and that was intended by Congress as the way the CZMA was written. So it fosters communication through the state's program approvals. It fosters a meeting of the minds at all levels of government, federal, state, and local. And in my mind, one of the really major measurements for success is the incredibly small amount of litigation that's occurred over the CZMA, over Commission decisions, even though there have been some extremely contentious battles with oil companies and others over how the process should work. Things have gotten resolved, or people have accepted decisions when they've been able to be equal partners or part of the process. One of the hallmarks is it's not the location of the activity, it's what the effect is on the coastal zone. And so we use our little fish here to, wrong side of the PowerPoint. I don't know how to get rid of that thing. Okay, so our little fish swim is one of our previous chief legal counsel said we use the fish swim test, so that's what we sometimes refer to it as the spillover effects. If species are spending portions of their life cycle in state waters, then we believe that those are species that we are authorized to protect, even if the effects are occurring outside the coastal zone. And a couple more examples of what we call these spillover effects. When you get to federal land, which is where a lot of our work is, we're talking about effects on sensitive habitat. Snowy plover is a good example on Vandenberg Air Force Base. Wetlands that are part of the Pacific Flyway, where the birds are flying, through the wetland on federal land, but to other wetlands outside the federal land. We have several inland examples. It's not as often that we go inland for our review, but dams, dam removals, sand mining, things that affect rivers, river systems. And as you're aware, the offshore oil drilling seaward of the coastal zone boundary, Navy sonar, those are some of the things that we've been reviewing for spillover effects on species that spend portions of their life in the coastal zone. The jargon that we use to save time as much as anything when we look at federal activities, there are two primary types. There are federal agency projects, and there are federally permitted projects, and there are different procedures for them. The first are consistency determinations, and the best way to illustrate that, I think, is when the Department of Interior creates the leases that it wants to sell to the oil companies. It's the applicant. There's no applicant yet for those leases. There's just the federal government. So they're what we call the C1 activity, the C1 applicant. It's under Section C1 of the Coastal Zone Management Act, under Section 307 C1. So we just call it shorthand C1 activities. That means federal government activities. Then you have the federally permitted projects, which are consistency certifications. We call them C3 activities, and that's an example of those. Exxon leasing and building a platform on a federal lease, the Orange County Toll Road, where the applicant's getting permission from the federal government. And there's a couple of important distinctions in terms of how the process works. There's a slightly different standard of review, although it doesn't come into play all that often. A federal agency activity has to be consistent to the maximum extent practicable, which has a legal definition. Federally permitted project, they just have to be consistent. The time period's a little bit different, roughly 2 months versus 6 months for the commission action. And then conflict resolution is probably the most important one. Commission action against a federal agency, an objection, it's not a veto. Federal agency is allowed under the law to proceed. The law simply says they have to be consistent or consistent to the maximum extent practicable. And that can be resolved through mediation or litigation, but neither the federal agency nor the commission has the final say. The final say is whether it's consistent, and that can be ruled on by the courts. When you have a federally permitted project, the process is different. You have an objection by the commission prohibits the federal agency from issuing the permission, from issuing their permit, and so the applicant can't proceed unless the project's appealed to the Secretary of Commerce and the commission decision's overturned. You don't have that commerce involvement in the federal agency activities. Just a couple of statistics. We've had about 1,300 public hearings on federal consistency matters. About 2/3 of the activities have been federal agency projects. There's approximately a 95% approval rate by the commission, where we haven't been able to resolve differences. If you go look at the other 5%, even in those, there have been few times when there's been a major problem, an appeal to the Secretary of Commerce, litigation, or a federal agency threatening to proceed in the face of an objection. So the process works. Things do get resolved an incredibly high percentage of the time. Here's a couple of instances where a federal agency did proceed despite an objection. The original lease sales that ultimately went, the interior lease sales in the 80s that went to the U.S. Supreme Court. Supreme Court determined that actually the commission didn't have authority and these should not be subject to CZMA review, and they relied on congressional intent, and eventually Congress said, actually, no, that is what we intended, and they modified the Coastal Zone Management Act to make it clear that we do have that authority. Navy home porting project, we had some problem with munitions in the sand and arguments over whether funding constraints could be considered an excuse for not complying with the Coastal Act, and that actually got resolved. And we had another case with the Navy sonar training that went to litigation. It was really resolved on non-CZMA grounds for the most part. And so, again, it's rare that this happens, and often we're able to resolve things anyway. In terms of the appeals to the Secretary of Commerce, they've been mostly, all but about 2 have been oil drilling cases, mostly exploratory drilling, and they weren't necessarily major battles, most of them, but eventually the commission did lose about 5 cases in front of the Secretary. This commission decision was overridden. The commission was upheld 3 times by the Secretary of Commerce. Most recent was the Orange County Toll Road and the Chevron exploratory drilling issue where the project where the issue was air quality. and exploratory drilling by Exxon, where the commission asked them not to drill during peak fishing season, and Exxon didn't want to have to comply with any restrictions, but the commission was upheld on that project. A couple of cases where the federal government has come in and helped us mediate conflicts with federal agencies, and successfully. Two examples, one at Pillar Point in San Mateo County, where there was an argument about a fence being put up to close access to an important beach. Actually, it's the beach that people go out to watch the Mavericks surfing event. That was resolved with the help of federal mediation. And we had another case in Port Hueneme where people in the area were concerned about the effects of radar, and the mediators brought in some experts, and we were able to manage to get issues that we hadn't been able to resolve on our own with the Navy through that one. So that can be successful. A couple of examples to illustrate where we've used maximum extent practicable to allow a project that's less than fully consistent. Just to be illustrative, we had a parking lot in San Francisco where the commission, for various Coastal Act reasons, thought the parking should be free so that the people wouldn't park out in the region and use up public parking spaces. But in this case, the federal authorizing law that allowed the parking lot to be built actually required that they charge the users for parking. So we accepted that in that case we couldn't require free parking. In a case with the IBWC at the border for removal of riparian vegetation, we thought it conflicted with several Coastal Act policies, but they had a treaty with Mexico. U.S. had a treaty with Mexico that guaranteed a certain level of acceptance of flow levels, and so we allowed the project with off-site mitigation to honor the requirements of that treaty. And then just a list kind of for I won't go through these cases, but again, it's a small number of cases that have involved CZMA and CZMA-related matters. Some of them were fairly major. The Granite Rock issue Lee talked about this morning. That wasn't per se consistency, but most of these cases are procedural. Most of them are in federal court, and most of them the commission has prevailed. But I just wanted to get the list out in case anybody's interested in having the citations. We have a list of federal permits that we have automatic review over, and if the permit is not on this list, an example, Army Corps of Engineers Section 404 permit, if a permit is not on this list, then we, the staff, the commission, has to request permission from OCRM, the federal government, to review a non-listed activity, non-listed federally permitted activity, which we've done on a number of occasions, and more often than not, we've been granted permission, but we have to do it. We have to do it in a timely manner, and it's just a process that is there, a part of the C3 process, the permitted process. Also, if a project's fully outside the coastal zone, other than OCS projects, if it's fully outside the coastal zone, even if it's a listed permit, we're supposed to be requesting permission to review it as well. And we have to just make the case that it's reasonably expected that there are effects on coastal resources. We talked fairly recently about the Broadway complex and the reopener. I just wanted to list the regulations on a slide, and there have been a few cases where we have used the reopener clause. Stillwell Hall was a good example. It's just down the coast from where we were an hour ago. The building was removed. The Army Stillwell Hall building was removed, but the seawall was still in place, and we argued that because there was no longer anything that the seawall was protecting, that it ought to be removed, and we used the changed circumstances procedures and eventually convinced the Army that it did need to be taken out. And there was a project in Hatton Canyon in Carmel also that we talked about the reopener clause because of new environmentally sensitive habitat that hadn't been sensitive at the time of the Commission's original decision. So it's just there when the Commission needs to use it. This is an actual listing for the secretarial appeal cases. I think the previous summary suffices, but I just wanted, again, to have a list of the cases. If anybody's interested, they're all, the decisions are all posted on our website. And we probably mentioned a few times, but when the project does get to the Secretary, they're looking at different tests than whether the project's consistent with the Coastal Act, with the Coastal Management Program. They're looking at, does the project further the national interest? Do its benefits outweigh its adverse effects? And are there reasonable alternatives? And so that's the test that the Secretary uses to rule on a project. And then lastly, I just have some maps for whoever's interested of where the federal holdings are in the coastal zone. We have 4 maps that show in different colored versions and have named the holdings, just to get an idea of where the federal lands are. Absent the CZMA, we wouldn't have authority over activities on these federal lands. And then down to San Diego. And then the very final slide is just a list of resources. We have links on our website to various federal consistency documents. Thank you.
Thank you. That was great. Are there any questions for staff? But I do appreciate it. It's, you know, I actually learned quite a bit from that, and
Right.
I've been here for a while, so thank you. Those refreshers are good. Even if they're not refreshers, they're just straight-out education.
And I do think it's, you know, Mark alluded to it, but for our Federal Consistency Authority, we wouldn't have a handle on some of these things. And so it's generally gives us that ability to do things that we wouldn't otherwise have on federal lands or over federal activities. One of the litigation cases he had listed there was the Monterey case on the Union Pacific Railway right-of-way, which when they began to abandon it in the 1970s, we said, hold on a second, you need to come to us for that. And ultimately, if you've been to the city of Monterey, there's a great rec trail that goes along that former railway alignment that, but for the commission using its authority under consistency to say that needs to be looked at, wouldn't be there probably.